All right, and to discuss the topic, general election petition court judgment, let's welcome to the studio Professor Yemi Akinshaye George. Is a senior advocate of Nigeria and a legal practitioner and Nigerian professor of public law and president of Center for Social Legal Studies. It's my pleasure to welcome you this morning.
Thank you.
All right, and Oluole Osaze Uzi is a lawyer, a former director of INEC, and presently Attorney General and Commissioner for Justice in Edo State. Sir, you're welcome, and congratulations. I'm hearing this for the first time.
Thank you, Karen. You haven't been following the news then?
But no. You see,
So
I preferred a one-on-one talk on this, so congratulations.
Thank you very much.
Yeah, and we're going to be having two guests via Zoom. And the one that is signal is ready is from Nairobi, Kenya. And he's Emmanuel Remi Ayede, Professor of Political Institutions, Governance and Public Policy, Department of Political Science, University of Ibadan. Professor Ayede, we're glad to have you with us from Kenya this morning.
It's a pleasure to be on Good Morning Nigeria once again.
We were expecting to have Dr. Osawaru Okunzua, public affairs analyst from Benin, much later from Oshu rather, in the course of the program. So, gentlemen, welcome to the program. And I want to start with our guest in Kenya. Perhaps you are in Kenya and you were not in Nigeria when the verdict was declared by the 5 justices of the Presidential Election Petition Tribunal yesterday. But of course, you've had the news, and I guess you also have been following proceedings since the petitioners went to court against President Bola Ahmed Tinubu. Let's get your take on the judgment. We'll do a kind of a holistic review of the judgment.
The judges have provided explanation for the decisions that they have made in terms of the petitions brought before them. And one very interesting part of that judgment to me is the position, which has been probably one of the most controversial, that the Federal Capital Territory is like any other state, and therefore does not enjoy a special status that make a two-third of votes cast, 25% of votes cast in the FCT, a requirement to be declared winner. I think that it's one very important position that has been very controversial in the public space, which the court has decided. With regard to the other judgments concerning the claims in terms of whether a candidate provided sufficient ground to show that they have won the election, or whether INEC's failure to upload the result from the polling units as stated in the guidelines is required. All of those are positions that I think Nigerians don't think are very damaging to the quality of the election. So, and then in terms of the witnesses that were disallowed or dismissed, and then also the argument that some of the papers were not properly filed, all of those I think are technical matters which can go either way. But that very claim, and then of course the whole argument that because of INEC's failure to upload the results, therefore the rules were not substantially complied with. I think this is another very important point that has been clarified. So my general view is that the judges have taken their decision. They have provided sufficient justification for the position they have taken. And if the lawyers for the various candidates still disagree with the tribunal, I think they still have an opportunity to go to the Supreme Court. But I think those are the two very vital petitions that I think will make a difference. That of compliance, substantial compliance with the Electoral Act, and then, of course, the question of the status of the FCT in terms of whether the candidates need to win 25% in the FCT to meet the requirement. And they have decided and they've taken very clear position on that. And if anyone disagrees with their position, then of course, the next place to go is the Supreme Court.
Okay, and that's exactly where the petitioners said they were going to, judging by submissions by their lawyers. Thank you indeed for opening this program for us this morning from Kenya. Thank you. I'll return to you as we make progress in this conversation. Now back to Abuja in our studio here. And I have a senior advocate of Nigeria with us. And of course, it's only important that you air your views on this matter. Nigerians have been, permutating, all this while. Suggestions were made by practicing lawyers, on where the pendulum will swing to. But yesterday it became clear and clearer, what the court has decided to do. So let's share your own view on the judgment, because of course it's an SAN show, it's a sound show, right? And you are one. Can we hear from you, please?
Yes, thank you very much. The legal profession, did us proud yesterday. I mean, clearly, when I talk about legal profession, I'm talking about the judges, the lawyers, and all of that. What you saw yesterday is a product of several months of hard work, diligence, research. That's what you saw yesterday, and when you are looking at a judgment, you are looking at what has gone into the judgment, and the test of assessment of any judgment will be the test of fairness. That's number one test. The second one is the test of reasonableness. And then the third one is the test of technical accuracy. I watched substantially the delivery by the justices. I saw evidence of fairness, reasonableness, and compliance with the law, what I call technical accuracy. So I think the delivery yesterday has elevated, in my mind, elevated the practice of democracy to a new level in Nigeria. It has again, the judiciary has again justified their position as the legitimizing, their legitimizing function. That's what happened yesterday. You see, and that's why there's calmness everywhere. Even those in court, those in court were enamored. Those in court were arrested by the quality of the delivery, the diligence that that went in the judgment. And let me tell you that the judgment yesterday did not say anything new. The judgment simply applied Nigerian election law, Nigerian election jurisprudence. For example, the way the issue of equality of votes, I think the approach was jurisprudentially sound. They said votes in the FCT and votes in any other state are equal, equality of votes. For me, that was the only issue, really. That was the only issue, really. Because the law of election in Nigeria is quite straightforward. And this law had been applied since if you look at that judgment yesterday, you trace it back to 1979, because they cited Awolowo and Shogare, Nwobodo and Ono, which are the classical foundations of election law in Nigeria. They progressively applied the law since 1979. The law that has been in the process of evolution. So I think what happened yesterday, for me, it's technically sound, it's reasonable, is fair, reasonable, and technically sound. So on these three scores, I think the judiciary, the Presidential Election Tribunal, has given us reason to be confident again that the rule of law is predominant in our country as far as election is concerned.
Yes, that's true to a very great extent. And we also have other resenting voices with respect to what have submitted, because you're all lawyers and legal practitioners. We also hear from some of you who have been elevated to the status of Senior Advocate of Nigeria, who have also deliberated on this matter, gave their own views, published their own views, and what have you. But what they have said that is very unique here is that the court exhibited professionalism, high level of professionalism in their research that culminated in spending over 12 hours delivering a judgment. That's understandable. Now let me go to Osaze Uzi, who is not just a lawyer, but also someone who played a key role at the highest level of independent National Electoral Commission. So you are double-barreled, and I'm happy you are here this morning. Now, look at the judgment. Before I take you on some specifics, with respect to INEC's, input in all of this, but look at the judgment holistically to say, look, what is it for you in this judgment? Your general assessment of it.
Thank you very much. Good morning, viewers. I defer to Leonard, Senior Advocate of Nigeria and Professor of Law, a very distinguished and a respected legal practitioner of many years standing. But I wish I could agree with him on all the issues he has raised, and I wish that Nigerians on the streets will agree with him on all the issues raised. Some will not, and there are some issues I agree with. No question about it that there's a lot of hard work, dedication, and professionalism put into it, not just by the lawyers. And I dare say, the lawyers in all the teams are some of the finest minds we have in the legal profession in this country. Very experienced. I don't think, cumulatively, I don't think hundreds of years of experience in election matters you will find in that panel. The justices of the Court of Appeal, it's difficult to fault them in any way, in terms of professionalism, in terms of industry, in terms of effort, hard work put into it. I think people should understand that. And stamina, mental and physical stamina, not just in sitting through hours on end, but also sitting through that judgment marathon. Most of us did not sit through the whole thing, and it's incredible. We must commend them. It's almost superhuman, quite honestly, or the four men and a lady who sat as justice of that. So that said, but I'm not so sure whether we would agree on all points raised in the judgment. My personal view on the whether Abuja is a super state is clear. I don't think, contrary to what Professor said from Kenya, I don't think that's the main issue in this petition. Abuja is not a super state. Abuja has no veto power, and as Professor Akinye George has said, there's equality of votes. If anything, Abuja is inferior to states. It's inferior. Abuja has only one senator. Every other 36 states, every state has 3 senators each. Abuja has 2 members of the House of Representatives. Each state, I think the minimum is 7. Some have as many as 20 or 22. So Abuja doesn't really count, but it's a federating unit. So when you talk of the Federal Republic of Nigeria, you talk of 36 states and the federating unit and the FCT. When you get that, you now understand that, yes, Abuja is part of the federating unit, but it's not superior. If anything, Abuja is inferior to other states. It doesn't have a governor. It doesn't have a state house of assembly. It doesn't have a house of assembly. So if anything, in my own view, it is an inferior federating unit. But for purposes of elections, there is equality of votes. So Abuja should not have veto powers. Abuja does not have a golden vote that will scuttle what 36 states. What if you did that? If you said otherwise, it would mean that a person can win an election, maybe by 10 million votes, and win all 36 states. Because he does not win the FCT, you say he has not won that election, and you go for a rerun. Now, the rerun will not be just in FCT. There are 2 reruns possibly, and the first rerun will be between the 2 people, the person with the highest number of votes and the person with the highest spread amongst the losers. They will now have to go for another election in the whole of the country, not just the FCT. So when you look at that, if you want to use and people forget that and is conjunctive, but it can also be disjunctive. When lawyers go to law school, the first thing in a university, in the graduate course they do, one of the first and compulsory courses is a legal method. And what they teach you there is that, look, amongst the things they teach you research, they teach you nuances of the legal profession. And part of what they teach you is statutory interpretation. And Professor will bear me out more eloquently put it. But basically is that, look, things are not always the way they are. There are rules which you apply to interpret any statutes, any constitution, or any document. Part of the rules, you have the mischief rule, you have the golden rule, you have the literal rule. And it says the literal rule you use first. But where it leads to an absurdity, and in this case, if you use "and" as saying that you must score 25% in Abuja, that will lead to an absurdity, because it will turn Abuja to a golden state, the golden veto, and a golden vote. So you do not use that rule. If you see, you can look, what's the mischief rule? What is the golden rule? What is the essence of the legislation? What are they trying to say? They're trying to say, look, to be president of Nigeria, you must have reasonable spread amongst several zones. Acceptability, not just your ethnic stock or your particular area that has total votes. You just get so many votes there, and then you're not known or popular in other regions, other zones of the country. That is the rule. That's the intention. But as for whether the issue of qualification is a pre-election or a post-election, I beg to disagree with what the learned justices of the Court of Appeal did. I think that these authorities, and that's where I disagree with Professor, the authorities seem to suggest, all these authorities from the Supreme Court, it's both pre-election and post-election. The difference is who can approach the court. If it's a pre-election issue, only persons of that party who took part in the election can approach the court, have the locus to approach the court. Prior to now, other people could, but now the law is certain that only those members of the party who took part in the primaries can question the qualification of any of their colleagues who were participants or equally that. But when it's a post-election, when it's a petition, any political party that took part in the election is entitled to question it. So that, I think, I differ from the judgment of the Supreme Court. Then there's the issue of uploading of the beavers. And this is a new thing. So we cannot go back to 1979, we cannot go back to 1989, we cannot go back to any other time but post-2022. And the law is clear. I don't know why the emphasis is on the guidelines. The law is superior to the guidelines. The Electoral Act does say that before collation, you must upload to the you must compare the scores of votes the scores of the accredited number of people as appears on the beavers machine with what is stated in the result sheet ECHA. First of all, that's the first thing you do. Once it tallies, you go ahead. If it doesn't tally, then it's a problem. You don't collect that result. The second thing you do is to collect the results. You must look at the scores from the IREV, uploaded from the polling unit. Actually, it doesn't use IREV. The law says take the scores from what is uploaded from the polling unit. The collation officer is supposed to see what is uploaded in polling unit and compare for each polling unit at the first collation level, each polling unit, what was scored by party A, B, C. You compare the total scores and you compare with the results that you have. Until you do that, that's a precondition to collation. That was not done, and so I disagree that INEC had the discretion. The discretion was removed from INEC and put in the law. The law haven't said so. You cannot depart from it. What effect that had, because each political party had the ECHAs, the fiscal result. What effect that had in the overall as to who won, who did not win, is a different issue entirely.
Okay, I'm learning new things. It's a legal method you talked about,
yes,
on the issue of a 25% of Abuja status that,
yes,
that you mentioned.
Yes.
And we've also heard and read from SANs in this country on this matter. And the most recent on the matter could be that of Buhari versus Yar'Adua and Obasanjo, as the case may be. But I don't want to go to that, because that's not the only issue raised at the court, by petitioners. There are other, technicalities. But the legal method you talk about, that means you say if and is a conjunction, it can also be something else.
It can be disjunctive,
conjunctive. So
yes,
are we manufacturing our own English or something, or is it an interpretation of it? But when you say and, it's automatically conjunct. I don't know,
it's not
maybe in terms of interpretation,
yes,
using legal method of what the and can be disjunctive. That's what I've learned now.
It can be conjunctive.
Okay.
Use statutory interpretation, canons of interpretation, or rules of interpretation.
Okay, all right. Yes. All right. Okay. Let me return to Kenya once more to Professor, who joins us via Zoom. Remi Ayede, you listened to other guests speak specifically on the 25%, which you started with, in your opening remarks. That's not to say that we are going to, remain on that, but you can make your comments, on their own position in that respect. Then there are other aspects of the petition that we have not really raised, and that is uploading, of results from the polling unit, which of course the court said is discretional in terms of INEC choosing what to do. Perhaps if in case in the process of conducting the election, and perhaps there's a hitch here and there, you could take a decision to say, look, I can get these results without abiding by what was agreed originally, which is to upload the results. Let's hear from you on all of this, and perhaps other areas you may like to touch on with respect to the judgment yesterday.
Thank you very much. I like what the former INEC person talked about, because we need to look at the principle, because this is very important in politics. Why, for instance, would the Constitution require 25% in the Federal Capital Territory? In the First Republic, and partly also in the Second Republic, our major concern about the nature of politics was the fact that most political parties, in fact, virtually the five important political parties, both in the First and Second Republic, were likely ethnic parties. In fact, one political scientist writing about the politics of the First Republic described the political parties as no more than ethnic armies contesting for public office. That was Professor McIntosh. And when we got to the Second Republic, the idea was that we have to find a way to ensure that parties are not confined to the ethnic group or geographical region of their founders. And that is why these requirements were introduced in the 1979 Constitution. In other words, politicians were then required to garner votes from virtually all parts of the country, by winning at least 2/3 of the states of the Federation. Previously, the Northerners would not even come down south to campaign at all, because by winning the North and having a stronghold on it, all they need to do is to then look for a minority party that they can enter into some kind of coalition with in order to govern. That was a very debilitating position, where you have political parties thinking that once they can keep their stronghold, they can then negotiate with other parties from other regions, rather than actually making effort to reach across or reach beyond their stronghold. So that 25% in 2/3 of the Federation was a very important electoral formula that gradually started transforming the politics of Nigeria, such that we have political parties that are non-national in character. There are other provisions of the Constitution to support that goal. So, in other words, these requirements must not be taken lightly, and that is why I think that if you also look at the wording of the 1999 Constitution as different from the wording of that of the 1979, you will see that the 1999 Constitution was particularly very specific. And then there's this debate around what is the implication of "and," whether it's in addition to winning 2/3 of the states, or whether the Federal Capital Territory is actually part of that 2/3 that we are talking about, if you treat it as like a regular state. Now, the judges have decided, and then we are waiting for what the Supreme Court will say, so that we have that final interpretation of that part of the Constitution. I'm not surprised that the controversy has continued in spite of this judgment, but when the Supreme Court interprets the Constitution, I think that will be the final interpretation, and all of us can rest on that. So it's still an issue that we'll just wait for the Supreme Court to give a final position on how we should interpret that constitution. Then the second one concerning the requirement of INEC, I think there's a huge problem around that, still on the basis of principle, because the whole idea of making that guideline is to shine the light on the electoral process, the voting process, the counting process, so that we make it more transparent. Now, we have a situation where it failed, or rather, INEC said it had a glitch, technology glitch, and therefore was not able to observe that rule. The question then is, what does it have consequences for the transparency of the election, for the integrity of the election, or people's perception or trust or confidence in that process? And my answer would be yes. And so the decision to say that INEC can bring a guideline and say, this is how we are going to conduct this election, and then once it has a technological glitch, it can then come out again and say, yes, we set this guideline, but then we are still free, to observe it or not to observe it. It's a little bit problematic, and that is why the decision needs to be looked at very closely. I have not done a very thorough examination of the argument that the judges have put forward, but I think that the Supreme Court will need to review those arguments and then tell us precisely what needs to be done in terms of the powers of INEC, regulation and guidelines, and whether those guidelines can be propagated, proclaimed from high heavens, and then come back again to say that it doesn't really count. I think these are problems because the transparency of the process is very vital. And given the concrete situation with the electoral process in Nigeria, what you observe is that between the collations, the polling unit result and the collation center, a lot of shenanigans normally happen. And the whole idea of uploading the result from the polling unit directly to the IRF portal is really to eliminate that opportunity for sense. And so if you then say that doesn't matter, then you then embolden those who have an eye on that gap to make some carry out some mischief, to think that it's all well and good, they can do it in the court, it doesn't really matter in the court. So I think these are issues that we will still want the Supreme Court to elaborate on beyond what the tribunal has said. And we also have to find a way, not just proclaiming very clearly whether those rules are applicable to INEC, but also to let us know what they think in terms of fairness, in terms of preventing future misdemeanor around that area during election. Because we have an objective for bringing the guidelines. And if the guidelines fail so woefully in terms of its importance, then we really have to think about how to handle the issue of transparency.
We appreciate that, and you've raised a very important issues that we're still going to deliberate on. And I'm coming to the Senior Advocate of Nigeria, who is here with us this morning. You may like to touch on some of the points he made with respect to what we have had discussed this morning. But again, I'd like you to add this. You see, you commended the judgment, the justices yesterday for doing a thorough job, for carrying out proper research and delivered judgment for over 12 hours, showing some level of consistency in terms of high-level professionalism, yesterday. That's understandable. Now, there are 5 judges there. We used to have the split decisions and what have you. Why did it not occur this time around? Does it mean that the 5 justices view all the items same way to have come with a single result?
That's what that's when we talk about technical accuracy. It also means consistency with the existing law. For example, the fundamental principle of our election jurisprudence in Nigeria has always been doctrine of substantial compliance. Nobody expects that you will have an election that is perfect. As far as humans are concerned, and humans are in charge of conduct of election, you cannot have 100% accuracy. So the Supreme Court, the Court of Appeal yesterday, has re-emphasized that fundamental principle of Nigerian law, which is called the requirement of substantial compliance. Another thing that they have re-emphasized, that's why I said the judgment didn't come to me as a surprise. The judgment is consistent with the established principles. That's why when they talk about appealing to the Supreme Court, let them, I think it will be good to go to the Supreme Court. However, I will expect that those issues that that the Supreme Court has already resolved fundamentally, it will be hard for the appellants now, to find fresh issues, new issues. And then you will notice that the judgment of the tribunal yesterday, of the election court yesterday, relied on judgments, on decisions of the Supreme Court. You found them citing Oputa GSC, citing Okoro GSC, citing Ogumiju GSC, insisting these are fundamental principles that have already been resolved. Another issue, that was adequately dealt with, another fundamental aspect of Nigerian law, is the issue of geographical spread. They dealt with the issue of geographical spread. Each of the candidates appeared to have won fairly well in areas where they have the highest number of supporters. Look at the way those judgments, those votes were analyzed, the spread, which took away all the complaints about the INEC being biased, awarding votes, and all of that. And then the issue of he who alleges must prove. It's another principle that was dealt with yesterday. There were so many allegations, but making allegations is one thing, proving those allegations is another thing. And then they also discussed the issue of dumping, whereby lawyers simply dumped documents on the court. And let me tell you, you see, when the PDP was in government, you see, and I said the chicken has come home to roost. When they were in government, the electoral law was structured in such a way that it will be difficult for a petitioner to prove a presidential petition or prove a gubernatorial petition, because the law says that you must call agents, you must call your agents at the polling stations who were there when the collation, when the collation was done and all of that. But in this case, we found you are calling experts. We are calling a European Union reports which were made by people, who were not present at the voting stations, at the polling stations. So I'll be surprised. It will be. We are waiting to see the grounds of appeal, which will go to the which will be taken to the Supreme Court. But as far as I'm concerned, then what about the issue of res judicata? There are issues that on the issue of double nomination. Whether or not the vice president, having withdrawn from the senatorial race, can be said, to have been a candidate for that election and then also nominated to serve as a vice presidential candidate. So for me, the judgment yesterday meets those three tests. The first test is the test of fairness. Is it fair? The second test is the test of reasonableness. Is it reasonable when you're analyzing a judgment? And finally, is the test of compliance, that's technical accuracy, compliance with the settled principles of law.
Has there been a time in the history of Supreme Court that the court decided on any matter concerning 25% on Abuja?
Oh, yes, it has been decided.
Let us know what happened.
Oh, no, there have been cases where the Supreme Court, I may not mention any specific case, but I've read, in fact, I issued a statement when the issue of 25% came up. I stated that the court has settled this issue, that votes in the Federal Capital Territory are not, just as my brother, the learned Attorney General, stated, there's no golden vote, as it were. The principle is the principle of geographical spread.
Okay.
Once that is established, as has been established in this case, that's why we're waiting to see the grounds of appeal.
Exactly. Thank you. And that will take me back, to what Professor Ayede mentioned with respect to how did it come about in the first place? Because of ethnic politics that evolved over time. And with respect to dealing with that,
yes,
that the issue of, okay, fine, you could well win in your domain, but then there's a central place, where nobody owns. that for you now to establish yourself properly, they have to get some percentage of votes in that environment based on the fact that it is not owned by anybody, and that the areas that are owned by people, you could well win there. That could be the philosophy of talking about and Abuja in the first place. Let's not go back there. But that's his own analogy.
Yes.
All right. And of course, Osase also told us what he felt about it as a lawyer as well. And you're also a lawyer. Now, let me take you on the issue of INEC, on the compulsory nature of uploading, from the polling unit. All right, because emphasis, has been laid on that several times by the appellant to say, look, that the head of the INEC has on several occasions publicly pronounced that it is even criminal if you don't upload and what have you. I don't know, but from what we heard yesterday, it became clear that the true position of the justices is this, that look, INEC has the responsibility to collate and declare results, and they can discretionarily take a decision on how to do it and deliver. What is your concern on this aspect?
My concern is that is not born, I understand, it's not born out by the understanding of the Electoral Act itself. And that's one of the revolutionary things that the Electoral Act of 2022 introduced that makes it different from all previous 2001, 2002, and all 2010 electoral acts. And that's what I thought I had disabused people's minds. But I listened to Professor Remy from Kenya. He keeps referring to the guidelines. The guidelines in addition, but superior to the guidelines is the Electoral Act. And Electoral Act is you have to, it's mandatory, you upload results from the polling unit. It's re-emphasized by the guidelines, yes. But the act is superior. And these pronouncements, ex cathedra by the chairman of the commission, that's important, but that is not statutory. It's important, but not statutory. But we can say he's stopped, but Electoral Act is dealt with by statute, by laws, by guidelines. So, but you can say I was misled by the officials of INEC when they said they promised, they reiterated, and if you listen to all their remarks, they're reiterating based on the law and the guidelines. Now, the law did not provide what will happen if there's a technical glitch. As it were, the law deals with absolutes. Do this, do that. For it to be valid, you must do this. Having not done that, and INEC says, oh, there's a technical glitch. Unfortunately, that was not taken care of by the Act or by the guidelines. The guidelines, to the best of my knowledge, were never amended to take care of where there are technical glitches. Before you start collation, the Act itself says you must compare those things transmitted from the polling unit. The re-emphasized in the guidelines. The guidelines says, look, before you do that, it gives more details about what the collation officer has to do and what the presiding officer in the polling unit must do. Before immediately you finish the results, you enter it into the ECHA, you scan that ECHA, and you upload it. The next level is the level of collation. You must do that. Every level of collation, you have to do that. The discretion, with due respect, is not with INEC, because the Act itself states so in mandatory terms.
Sir, what is the difference between law, guidelines, and Act?
Okay, good. Now, there's what we call a hierarchy of laws, and I think you should be asking the professors this really, because the Constitution is supreme. It's the most important law of the land. Any other act or anything that's contrary to it gives way, because it's what binds us together. It's supreme. Next in the hierarchy of laws is an act of the National Assembly on things that the National Assembly can legislate on. That is the next thing to an act, and is valid for all purposes. It gives flesh to the constitutional provisions. Next to the National Assembly Act are guidelines. That's subsidiary law. They are guidelines. They are made by executive bodies pursuant to powers donated to them by acts of the National Assembly or by the Constitution. So where there's a conflict between guidelines and an act, the guidelines will give way to the provisions of the Act. Where the Act has not made provisions, then you give details in your guidelines. So the Act is like a skeleton. The guidelines now gives flesh and blood to that skeleton. The skeleton is upright structure, superstructure that gives power to guidelines.
An ordinary man like myself,
Yes.
Would ask, why do we now have to bring in law, bring in guidelines, bring in Act on one particular issue that will now begin to make it easy for manipulation? I mean, what people call lacunas, in terms of implementation, because what happened is that trying to implement the Act on the act establishing the guidelines that INEC followed for this election, you see little discrepancies here and there, manipulative tendencies and what have you, comes up based on the established law. You see, my worry is this, sir. We keep talking about law reform, and law reform. Yes. And one would have asked, what has been reformed? And why is it a difficult thing to be able to define an act by lawyers or SANS? I mean, you have an act, yes, subsections and what have you, yet it is problematic to even discern when both learned persons will be arguing on a matter that's been specified, in a document called Constitution. That's what worries ordinary Nigerians. To say, look, yes, like you said, you have to prove something. Something happened. You go and prove it before it becomes factual. That's understandable. But then, in trying to prove such things, and you have some lacunas or some stumbling blocks along the line, proving will ordinarily become difficult. So I want to introduce a new guest. I hope he's there with us now. From Osogbo, the Osun State capital, Dr. Osawaru Okunzua, public affairs analyst. He's also a regular on Good Morning Nigeria. Dr. Okunzua, you're welcome to the program. Yeah, I think we're having issues with his audio line. I didn't hear him clearly. Let me say hello to you again, Okunzua. Can you hear me clearly? All right. Our technical crew will do something about that, so we can have a clear signal from Osogbo. Well, let me go to Kenya once more, where we have one of our guests. Prof, you've listened to other guests and the issues I have raised in trying to do analysis of the submissions from the guests, and you may want to touch on one or two things concerning their own submission. But again, is there an issue with our constitution that requires to be amended? We have been amending and amending like other constitutions in other jurisdictions, but somehow after amending our constitution or even doing some law reforms, we still find it difficult to practice in such a way that Nigerians will be satisfied with what we may call a judicial dividend of democracy.
Well, I don't think in this particular case that we have an issue of constitutional amendment. I think that if you even look at the amendments we have made so far, majority of the amendment relates to the electoral process. So in terms of elections, I think that we have had more than the fair share of constitutional amendment in that area. What we have that we are discussing so far, it's matters that relate to movement, as Dr. Uzi has mentioned. If you look at the hierarchy of the laws, when you get to the question of the Electoral Act, you also notice that after several amendments of the 2010 Electoral Act, the 2022 Electoral Act has repealed that Act. Now we have a fresh, a new law concerning all of this. What we have on the ground is a matter of interpretation. I think largely that is. And then we also want to know, for instance, what is the status of the guidelines issued by INEC? Because for me, that is actually the crux of the matter. If the guideline, for instance, as Uzi mentioned, is a subsidiary law, which is, of course, it's not as strong as the act which inspires it. The question is whether that a guideline binds INEC, because that's actually the crux of the matter. So for instance, if you look at it from the principle of fairness, will you give out a guideline and then circumstances makes it impossible for you to follow your own guideline? What are the consequences of that situation? How do we define a instance, a justifiable circumstances that will make your non-compliance with your own guideline not significant, and what circumstances can make it significant, because these are human affairs, and that's because the whole idea is if we want to pursue transparency, everybody agrees on that, and the guideline enables us to do so. The question is, in every human situation, of course, there are situations, there are cases where it may be impossible or difficult to follow the guidelines. Now, in the case that we are dealing with, was the glitch in technology justifiable? I think these are the issues that we want clarified, and we are not satisfied with the position of the tribunal, and we want a deeper explanation of those. And then my own concern specifically will be if we have this situation that has been upheld by the Supreme Court, and it says INEC is not confined to comply, not compelled to comply with this kind of guidelines. What would be the situation for the voter, for the political party, and also for those who are concerned with improving the quality of the management of elections? We have to wait for the Supreme Court to clarify its own position. Then what will then be left for us is to begin to think around it in terms of administration, in terms of management, and so on and so forth. That's my concern with that. So it's not necessarily about constitutional amendment. It's about if you have to move from, as an executive body, from the powers that are given to you to issue some kind of directive, what circumstances will make you not comply with your own directive? And if you don't comply with your own directive, what are the consequences? And if the Supreme Court says, the consequences are not significant, but we will still be concerned with transparency. What other innovative ways should we think about in trying to achieve that? That would then be the challenge post Supreme Court judgment. I don't really see a case for constitutional amendment here. It's rather a lot that has to do with the administration and management of election, and it's a big challenge for us in Nigeria going forward.
Professor Ayede, that's administration and management of elections, which has become a turmoil on the African continent. Elections are usually fought like wars, which should not be. It's a game. If you win, you win. If you lose, you lose. And you're watching Good Morning Nigeria on the network service of the NTA. We've been deliberating on the Presidential Election Petition Court judgment of yesterday, which is resonating among Nigerians. We're glad you are with us up to this moment on Good Morning Nigeria. Stay with us as you take a short break. We'll be back. All right, you're welcome back, and we are glad to know that you're still with us up to this moment. You're watching Good Morning Nigeria on NTA Network Service. We're back to the studio here from Kenya, and I have my guest in the studio still with me. SN is here, and of course Barrister Osaze Uzi also here. Gentlemen, we have come a long way in this conversation, and as we round off, let us look at remediations. What has happened. We are still waiting for the appellants to go to the higher court, Supreme Court of Nigeria, for their case to be determined. But looking at the entire scenario and what played out from 25th of February till today, one could say is not a healthy development for a nation that has, of course, witnessed democracy, uninterrupted democracy for over 24 years. And so where do we begin from in terms of remediation? Do we really need to do more in terms of guidelines or acts guiding elections in Nigeria? Do we have to go back to all of that again to see how we can fine-tune what has been done? Since, of course, we could not follow all that has been articulated to the latter, perhaps for one reason or the other. Is there any other means we could do that? Can we emulate directly from other Western nations who have mastered elections. Yes, there's no perfect election, but there could be something near perfect election that people could say, look, this election has been properly conducted. This election has integrity. This election is fair, and what have you. Let me begin with you, Sam.
Let me quickly say this. Nation building is a never-ending process. Nigeria has done well by sustaining democratic practice in the last 24 years. We have confidence in the courts. That's why, commendably, those who lost the elections took their matter to the court. And the court has made a pronouncement. The Court of Appeal has made a pronouncement. And the pronouncements of the Court of Appeal is substantially founded on existing law, already declared by the Supreme Court. What more are we looking for? The role of the judiciary is to tell the parties, you are wrong, you are right. And they have said so in clear terms, applying existing law. For example, my learned brother, Dr. Uzi, stated that we have Nigerian law, unlike the laws of any civilized country, can be found in, on levels. We have regulations at the lowest level. Then the next level, we have acts legislation, acts of the National Assembly. Then we have the Constitution. If you look at this judgment that the Court of Appeal has just delivered, they were talking about the Constitution as the supreme law. So where there is any regulation or a provision of the Electoral Act that contradicts the Constitution, they simply said, this is what the Constitution says. For example, on the issue of qualification of parties to stand for election, they said if there's any legislation that makes a provision that is not in line with what the Constitution says, we are going to stick to the Constitution, and we are safer that way. That's what is called the rule of law. So the standard of proof of elections, another principle that was established in this case, is balance on the balance of probabilities. And when you make allegations of crime like manipulation, violence, and all of that, you prove it beyond reasonable doubt. And with that, we have not had such high level of proof by any of those parties who made allegations of manipulation, and a couple of criminal allegations that were made were left unproved. So the Court of Appeal has simply applied the law.
Okay.
So it will be difficult. I can say without sense of responsibility that it will be difficult to follow the judgment of the court. And mind you, it was unanimous. And you can see the brilliance, you can see the erudition, you can see the diligence, you can see the effort, the professionalism that went into those judgments. All the judges did not, all the justices did not simply say, I concur. No. While concurring, they gave reasons, clear reasons, why the judgment of the lead judgment, could not be faulted. So I think that we should learn, like good sportsmen, we should learn to accept defeat. It is not in every case that we must. The law is quite clear on some of these points. Yeah. So I mean that's my attitude to this, all of this.
Yes, that is good. And Professor Ida also talked about the interpretation of the Constitution itself, because from interpretation you hear different perspectives to that, even by the highest level of legal practitioners in Nigeria. There's always this issue of, okay, let's go to court and dig it out. And some will be applying some technicalities. We used to hear interlocutory injunction. We used to hear somebody would say, look, you are being investigated. You go to court and say, look, you stop them from investigating me. And the court will do same to say, look, don't investigate this man. So some Nigerians don't understand that. Perhaps it's in technicalities we're talking about, or it's in the method you're talking about, and what have you. But for a court to say, look, don't investigate this man, maybe a layman don't understand it. So that's why we talk about interpretation, as I did a short while ago. Now, let me try and bring in back Dr. Osawaro Konzoa once more, who have been trying to join us from Oshobo in Osun State. Dr. Konzoa, let me hear from you again. Hello and welcome to the program.
Hello, Kiri, and good morning to you and our friends.
Yes, I can hear clearly, but your picture is still blurred a little bit. I hope it can get better. But as you are now, let me stay with you, because you are making your first contribution now. You know all about the judgment, and we would like to hear your own view about the judgment. All the efforts put in place since the judgment, the case started some months ago, and of course, what we have seen as a final delivery of judgment by the 5 justices of the Court of Appeal. What's your take?
Our compatriots between the studio and one in Kenya, I think what they have said, I ordinarily align with. But legalism should not infect our electoral process. The professor with you in the studio has talked about our evolution since 1999, how we have been stable. Of course, yes. When people feel law, and we have to commend Atiku Abubakar and Peter Obi for approaching the court to ventilate their agreements. But as a citizen, I believe the legalism in question to the application of for me, I think we should stay with it. We should be able to devise a political system that is sufficient, that will not be interfered with the legal processes and the rest of it. Because going for an election is people going to express their franchise. We should be able to construct an electoral system that will give satisfaction to all our citizens, that will promote a sense of sportsmanship. So much so that when you look at the ballot box, you are able to feel you have been treated fairly. And when you also win, you know you have a fatal mandate. So our very brightly. Any person who watched yesterday from any corner of the world would know they were very, very rigorous. They were there for half a day, even longer than 12 hours. And they explained every decision they took, even getting other fast to buttress their conclusions as citizens. Just an analysis now. I think I was praised. But is the electoral system we have to keep?
Yeah, well, Dr. Osaru Okunzua, we are still having issues with your audio line, and it's been distorted along the line of communication, so we can't get to it clearly. We are sorry about that. We may try before the end of the show to see if we can get a few more words from you. But we also like to thank you for all the efforts that you have made to be able to reach us this morning. So back again to the studio. Gentlemen, electoral system in Nigeria, has it defied all known and unknown methods and approaches to election? I recall when we had an election that was adjudged as the best in Africa. That has not been replicated. And that's option A4 system, which was applied by one of our known political experts. And, he said, look, that he has studied Nigeria. He has studied the characters of our people. He has studied our demeanor in terms of, planning to achieve success, that we go to the extreme to do that, especially during election. People are prepared to die. As a matter of fact, there's no election since 1999 that people did not die. There are no two ways about it. It's on record that has happened. And he brought in what is called option A4, which was said to be primitive. He said to be, how can we come and stand on the line and go, that is not even, yet it yielded results that has been authenticated by not just the people in power, but by ordinary Nigerians to say, look, this election went free and fair. Are we now going to be like America, without copying America properly, without articulating all the things that they did to have a perfect election or near perfect election? Can we go back to option A4, something that we can understand? We may have been learned, we may have gone to school, but the point is, when we want to deliver, we want to implement anything in this country, it becomes a problem. So, is it not character? It's not in our blood to do that. So, option A4 solved the problem, a problem of integrity in this country when it comes to election. You could say it's crude, whatever it is. Or says you've been in election business for a while, for a long time. And you know that even Yar'Adua, when he came to power, said, the election that brought me was not good. He said so. And I mean, we are still struggling with this election system. We're still struggling. I mean, Oseze, let us know what we can do in terms of remediation, so we can stop all these going to court and stopping government in power from doing what it has to do.
Thank you. You raised some fundamental issues there. But first of all, you said talking of you referenced the U.S. You forget that. Al Gore and Bush is still fresh in our minds. 1984, and they had issues. You've forgotten that.
Yeah.
You've also forgotten that Donald Trump, not so how many years ago, less than 4 years ago, there were also issues with the American election. So don't be too hard on Nigeria. Nigeria, there's a lot. We've got a long way to go, but don't take everything as perfect, please. Please, if you Google the British elections, for example, you'll see issues that rose in their own elections, but their systems are robust enough to deal sufficiently with those issues without losing complete confidence in their systems.
I like this.
That's the difference.
The system is robust enough, because
The
even in
system.
the British election I talked about, I saw them. They were counting.
Okay, don't take the election. Don't take elections in isolation. Take it in the gamut of the society we live in.
Yes.
That's the point. One of the points I'm trying to make.
Yes.
When I say the institutions, I mean all the institutions put together, including the judicial institutions, the administrative, the executive, all the institutions put together. So don't take elections in isolation. That's part of the thing. We look at our societies in total to put things in context, to put things right. So we're not perfect. We're far from it. We're far from where we want to be. And the issues of confidence. And part of the issues, you say, when you say election is good, is fair, there are all sorts of things you look at. This is an election, for example, where from the official figures of INEC, whether you agree or you don't disagree with INEC, 2/3 of Nigerians did not vote for the person declared winner. But that's the system. 2/3 of the people did not vote for the APC from the official figures. But because of the system, it's first past the post. Because of the systems you have employed, the man has been returned. So majority of there are some states in West Africa, Niger, Chad, and people like that, where you must get the majority rule applies. In other words, you must get 50 plus 1. If any of the candidates gets up to 50% of the votes plus 1, then they will have to go for a runoff. Yeah, there are other things that they like South Africa that deals with proportional representation. So there are all sorts of things, but this is the system we have adopted. If Nigerians feel it's not ideal, it's not good, why should somebody who only scored 1/3 of the total votes card be ruling us? Then that's a different issue. We'll go back and then amend the constitution. But option A4 that you keep talking about, and let's get this clear, people confuse option A4 to open ballot, and what you're talking about is open ballot. But if I recall correctly, Abiola's election was not open ballot. The one preceding it, the local government and the governorship election was. But the 1993 presidential election was not open ballot. Let's get that right. And you have a duty to find that out and enlighten Nigerians. It was not open ballot. So when people make this confusion and take us back, and that was 30 years ago, we cannot go back to open ballot system. Now, why it was amended and it was not used as open ballot was not used was because of the repercussions and the social effects of what the open ballot did. Tenants were quit from their house because they voted against the landlord's wishes. Spouses were separated. Fights arose between tenants and also because of this open, but it was open intimidation. And even in the counting of the votes, you remember they say 1, 2, 10, 12, 15, 20. These things happen. So malpractice is a thing of the mind. It can happen with any system, whether it's open ballot or whether it's secret ballot. But international best practice, and including our own local things, it has to be secret ballot. We can strengthen other things, but let us not go back. Let us even start that conversation of going back to open ballot system. It's a no-no. I think everybody, regardless of where you stand on this divide, everybody were unanimous in that you cannot go back there.
Okay.
You work for NTA. If your MD had come and said open ballot, all NTA staff must vote for X or for Y. You know what will happen if you don't. You can't go back there.
You see, we sometimes run away from reality, because there is no system that does not have advantage and disadvantage.
Absolutely.
Yes, open ballot has its own disadvantage.
Correct.
But if your landlord has to eject his tenant, the tenant should look for another house, because you cannot buy your conscience because he has a house. You look for elsewhere. But if you can solve the major problem of elections, that would be better for the nation. Collectively speaking, that's from my personal opinion, which I shouldn't share in the first place. All right, now let's return to Kenya. We are rounding off the show gradually, Professor Ayede, and you listen to Osaze. I was trying to introduce option A for the timid and antiquated system that yielded results, but Osaze did not tell us whether he did not say that the election of that year, 1993, was the finest in Africa. The result was the finest in Africa, like everybody agreed to. So, what's your take, briefly, please?
I don't think it's necessarily because there was open ballot or even that there has been experimentation with option pay for. I think the real challenge was that people were just fed up of military rule, and they wanted to just move on to a democratic government. And people behaved contrary to the expectation of the military government that was looking for excuses, to postpone the transition. So it's a different environment. But I think one problem that we need to address, which I think it was former Governor Kayode Fayemi was talking somewhere about adversarial politics, that when they see what is right for the country, they pretend that it is not right simply because they just want to win power by all means. I think that's one problem that we need to deal with. We need to get to a situation where through either institutional change or even through change of law, we can get the kind of behavior that we expect from politicians and also from citizens. I think that we have a lot of work to do, and we must recognize the fact that we are just like every other human beings in any other country that there is, and we need to do some kind of social engineering, and meaningfully so, rather than just paying lip service. Power must not be an end in itself. Power must be an end towards development, towards making life abundant for citizens. Once we're able to agree on these basic principles of governance, then we can begin to even change our laws if there is need for them to be changed, and then we'll achieve the kind of purpose that we seek. I think currently there's still no consensus among politicians and the political elite. They are still struggling to the death on the access to political power. Once we are able to settle some of those basic things about governance, we'll be able to improve on the quality of our election. But in the meantime, I think that INEC has a lot of work to do. It has tried, and it will have to continue to strive to make the election management system better and better. But our hope is not lost, and I think that the fact that we have the opportunity to even go process the challenges through the legal process is also create some kind of stability and hope. Elections don't give us final victories. They are temporary victories, and politicians need to understand that.
Gentlemen, I'm not trying to have much on option A for open ballot or what have you, but when you said that people were in a hurry to take away power from the military, we had two candidates who vied for the election. One had a Muslim ticket. It never happened before, but people voted for that ticket, and they won outrightly everywhere across the nation. No discrimination, nothing. There were two candidates. It was not necessarily to remove the military, but we had a good judgment by the voters at that time. We are rounding off, as I said earlier. Your final thoughts on this subject matter?
Yeah, thank you very much. When we talk about democracy, what underlies democracy is the democratic ethos. The mindset. What the candidates, the petitioners have done in this case is they have expressed their confidence in democracy by going to the courts. And that's the legitimate thing to do. Rather than embarking on violence, resorting to violence, they went to court. But the logical outcome of that, the logical corollary of that is that you must have the discipline and integrity to accept the outcome of the process that you initiated. The lawyers have done an excellent. All lawyers on both sides have worked excellently. They have brought out the law, and the court has said this is the law. And I have told you by my research of over 30 years, what this court of appeal, what this election court, the election court has done is they have applied Nigerian law as we know it. And my brother, the learned Attorney General Oluwole Uzi, has stated that the principle in Nigerian law is first past the poll. That's what the law is at the moment.
All right.
So if we are not changing that law, we must have the discipline to accept the application of that law.
All right. Okay, gentlemen, it's been a wonderful conversation this morning. You've learned a lot. Nigerians have also learned a lot from these legal luminaries, if you like. And I'd like to begin to appreciate them. Professor of Public Law and President Center for Social Legal Studies, Professor Yemi Akinseye George. We thank you for being here this morning.
Thank you.
And for sharing your thoughts with us. Dr. Oluwole Osaze-Uzi, who's a lawyer, former director of voter education and publicity, INEC, now Attorney General of the government of Edo State. We thank you for finding time, with your new title, finding time to be here this morning. Thank you.
Thank you for having me.
We appreciate that. I would also like to extend this appreciation to our guest via Zoom from Kenya, Professor Emmanuel Remi Ayede, Professor of Political Institutions, Governance and Public Policy, Department of Political Science at the University of Ibadan. We thank you indeed. And I hope you're having a good time in Kenya out there. Dr. Osawaru Okunzua tried to reach us, made a lot of efforts, but we had him very briefly. We'd like to thank him too for being with us this morning on Good Morning Nigeria. All right, next perhaps. All right, we don't have time for the other segments we earlier promoted, and at this point I'd like to thank you immensely for being part of our show today. Do same again tomorrow when we return with a fresh edition of Good Morning Nigeria on NTA Network Service. I am Kirian Umayo. Do have a great day.